meeting with accounting officers, and it's possible that there could be the cabinet secretaries and principal secretaries in sectors that involve the water and national and natural resources, environment protection, and later on in the day he is expected to meet with accounting officers and also principal secretaries and even possibly the cabinet secretary of education. This meeting, Fred, is in regards to the budget review process, which is currently taking place. It is a week-long process where meetings will be held during the morning session and also the afternoon session. There are expected to be 10 sectors coming in, and as we've mentioned, like in the morning it is the natural resources and environment, and in the afternoon the education sector. And this in line with the President's 4 priority agenda, which he mentioned during his inauguration speech, where he said that in the next term, this being his second term, he is going to focus on manufacturing. He's also going to focus on affordable housing. He's also going to focus on universal health coverage. And lastly, the President said he's going to focus on manufacturing. This sector, the National Treasury, that is the CS, has been tasked with ensuring that in regards to the budget, everyone is being given a zero budget, and from then they have to come here at the National Treasury to convince the ministry and also the cabinet secretary and also his key officials that the money that they need come 2018-2019 is going to go to these top priority agendas. And even if we mention that energy might not be among the priority agendas, when you look at manufacturing, it is a sector that requires energy, and that is why the cabinet secretaries along with the accounting officers are said to be needed here during the week. And when it comes to an issue like housing, where the President has promised that he will provide 500,000 houses in the next 5 years, the houses are said that they will be built in areas where factories and industries are going to be set up by the government, and these houses are to be for the people, that the jobs that will be created in these industries and also in the factories, the houses will be built close to those areas so that the people can be able to acquire these houses. And also possibly sources have indicated to us that in regards to the housing sector, there might be a ministry that will be set aside for the housing sector, it being one of the top priority areas the President has put aside. And there we see that currently the ministry falls under that of the transport, urbanization, infrastructure and housing, which is such a large ministry that has then that one ministry having 5 principal secretaries, and there is a possibility that this might be split. And also when it comes to manufacturing, the President has been keen on agro-processing where they say there might be a state department of agro-processing that will be created in order to facilitate the job creation that the President has spoken about. And after the week-long meeting, Fred, it is expected that President Uhuru Kenyatta will reveal more on what is going to happen, the budget that he will set aside for his next term, as this is going to be the hallmark of his second term, and this will be revealed during the Jamhuri Day speech, where Kenyans will be able to know more of the areas where the President is going to put his focus on. Fred?
Thank you, Mumbi. Mumbi Waroi there outside Treasury, where a week-long meetings have kicked off at the National Treasury to align the 2018-2019 budget to President Uhuru Kenyatta's 4 priority areas that will define his second term. We do understand the joint meetings will see CSs and PSs and accounting sectors of 10 sectors defend their budgets. Back in studio, we're now joined by a different set of panelists. We do have Kakai Kissinger, an advocate of the High Court, also a former registrar of the judiciary, as well as Njenga Kamodo, also an advocate. Good morning, gentlemen. Karibuni sana. Of course, 2 issues to do with that I would need some advice in terms of legality or matters to do with the courts and stuff like that, because one, you've just seen what's happening at the DCI headquarters with lawyer Senator James Orengo being barred from accessing the DCI headquarters. They do suspect that NASA strategist Ndii is currently holed up in there. Also happening this morning is that CJ David Maraga is launching a week-long event dubbed the Mediation Settlement Week by the judiciary, where the courts are encouraging various litigants to opt for mediation services provided by the judiciary. Let's start off with what's happening at the DCI headquarters. When someone is arrested in Kwale and brought to Nairobi and we see all these things, what exactly happens? You're both lawyers, and I'm sure Senator James Orengo is going there in his capacity as a lawyer as well. Why would a lawyer be barred from accessing the DCI headquarters? Let's start from there.
I don't know under what circumstances he was arrested, but going by what we are reading on the newspaper, there are then things that probably the DCIO and the police want to investigate. Arrests are normal. Transfer from where they arrested him to Nairobi is normal because probably they want to find out more details or whatever it is. No one knows. But I think any person who is arrested has a right to an attorney, has a right to have a lawyer. It's good to see that James Orengo and company are there to give him support in terms of moral support or what legal advice he needs. Now, two things can happen. Either one, that it's not a time for him to probably talk to a lawyer and are still trying to interrogate him in private before they allow the lawyers to come in. But at the end of the day, trust me, a lawyer will be allowed to talk to him. Because sometimes when they are doing interrogations, the police probably wants one-to-one or individual-to-individual discussions before then they call in the lawyer. So what is important is that at least the lawyers are there, and we hope that they will be given an opportunity to talk to David Ndii to find out exactly what happened, if he's actually in that station.
But Makamudo, that access to your attorney should be automatic. Is there a certain time, as Bwana Kissinger says, a certain period when you're not allowed access to your attorney?
Well, we may want to begin by considering the circumstances under which the arrest has been made, because as far as now we don't have firm information which would enable us to make a binding.
But is there such a provision that there are certain periods when you're not allowed access to your attorney?
Ideally, the Constitution provides that an arrested person retains the right to communicate with their attorney. So I would want to understand deeper why the situation is the way it is. Because I do not have the full facts, I would hesitate to state.
Because the question I asked you was very direct.
Yes.
Is there any time that any person is not allowed access to his lawyer?
I'm not aware of such a situation.
Yes.
That's what I'm saying.
Okay.
In this case, it would be good to get the information, the right information flow, and know what exactly is happening or what the situation is.
Yes.
And the circumstances that
the
are inhibiting.
The other issue that we are made to understand is that any person who is arrested in Kenya has to be presented in court within 24 hours. Yes?
Yes, that's a constitutional requirement. Once you are arrested, then you must be either taken to court before the 24 hours elapse, or then you have to be released immediately. Now, but there are exceptions, whereby if you go beyond the 24 hours, then the police has to seek for an order.
Before that?
During the investigation. When the 24 hours are over and they realize they have not finished the investigation, then they can seek for an order to retain you a little bit longer. But then that now they involve a court order. Now I don't know, but ideally within 24 hours you should be arraigned in a court of law. And those are some of the benefits of the new constitution and the changes that we had, and also the Evidence Act, the Police Act, and all this kind of statutes. So ideally within 24 hours have all investigations done, if not seek for more time to, like in murder cases for example.
Yes.
You can go beyond 24 hours.
But either way you have to
in terrorism cases, you go beyond 24 hours. But then there has to be a reason why you are going beyond 24 hours, because probably they will be saying that we need more investigations, we have not finished an investigation. Remember, 24 hours is very limited.
But someone would ask, then when does an arrest take effect? When can I be considered to be arrested? Because I could be within a police station, but I'm not under arrest. Therefore, I'm assuming the 24 hours would not apply for me. When does an arrest take effect?
An arrest takes effect right from the moment that you are booked in as having been...
So you have to be booked in the OB?
Yes, you should be booked into the OB. Yet, we must look at it in a more in a more critical sense, because at times it will be necessary, and it's provided for by the law, that the police take time to interrogate the circumstances, and this will involve having a conversation with either the arrested person or the person to be arrested for that matter, so that they can establish indeed whether this person has a hand in, let's say, an alleged criminal activity that is being investigated. And once they have concluded or have decided that the person they are holding is party to the crime under investigation, then they can proceed either to charge the person, or if they establish that the person they do not have sufficient evidence or grounds on which they can pursue charges successfully against the person, then the person will just be...
Are you saying that the police can hold someone without necessarily booking him? And in that case, that person would not effectively have been arrested?
Well, there is some dilemma there, because when police get to arrest you, or the first encounter, the first time the police get hold of you, most probably you will not be at the police station. Yes. So there will be a duration, ordinarily, between the time when the police lay their hands on you and the time now you get to the...
So at that point you're still not considered as arrested?
Well,
because the question is, when does the 24-hour period start? It's after you've been booked in a police station.
Ideally.
Yes. So if at all they hold you for 24 hours without necessarily booking you at a police station, that means you've not been arrested yet.
But the Constitution doesn't envisage a situation where the police will hold you incommunicado without having to produce you, because they have to produce you in court within 24 hours. And in the event they don't, then the law provides for another called habeas corpus, where you can petition the court to have the arrested person produced in court.
Okay.
So basically, the moment you're in the custody of the police, then the 24 hours starts running from there.
Okay.
And so 24 hours, then you should be arraigned before a court of law. Okay.
We're still following the proceedings at the DCI headquarters, where the NASA leaders led by Senator James Orengo are still locked outside the DCI headquarters. They're trying to access the facility. They believe that NASA strategist Ndii is currently holed up in there, being interrogated. But they've been barred from accessing that facility, and even the allegation that Ndii is currently holed up inside there is still, we can still not establish that fact. Let's move to a different event. We do understand our reporter Patrick Igunza is at a different event where Safaricom is launching a facility for the blind or for the visually impaired. A very good morning to you, Patrick. What exactly is happening? Unfortunately, we've lost our connection with Patrick Igunza. We continue this discussion here. Something else that's happening is that the Chief Justice David Maraga is today presiding over the launch of the Judicial Mediation Settlement Week, where the courts are encouraging various litigants to opt for mediation services provided by the judiciary. Bwana Kakai Kissinger has worked in the judiciary for quite a while. What exactly is this that they're launching this week?
You see, what the Chief Justice is doing right now is what is anchored in the Constitution. The Constitution, Article 159 of the Constitution, lays down a basis, which is Chapter 10 of the Constitution, lays down a basis of why we must have mediation. Actually, they call mediation, reconciliation, and alternative dispute resolution. Now, what that just means that the Constitution sees a situation whereby judiciary might be overwhelmed with cases that go through the normal trial in terms of hearing processes. And so the spirit of the Constitution is to come up with alternative means of settling these disputes. So that was anchored in the Constitution. It runs through quite a number of articles in the Constitution, beginning with 159. Now, what then this means is that the judiciary is recognizing that we have many cases going on in court. Litigation is very high in this country. We have few or limited judges or magistrates. So why can we come up with a week? Actually, it's running from 4th to 8th. Why can we come up with a week whereby litigants can come to court and say, we want to solve our matter amicably, whatever the cases that took place. So it encourages or fosters the spirit of reconciliation, meaning you don't have to go all lengths to discuss issues that are before court. So those matters that can be solved, ideally, then you pull it out. So it's a very good thing that the Constitution is doing. It's a very good that the judiciary is doing in terms of fostering this. So judiciary has in the past been encouraging mediation, reconciliation, and alternative dispute resolution, so that you minimize or you declock the case.
But someone would argue that the judiciary will still have to depend on its own resources. Going back to get these mediators, who I'm assuming are people who understand the law and probably work within the judiciary, to come and mediate. Aren't you just doing the same thing in a different way?
No, sometimes what the judiciary does sometimes relies on its pool. Remember that some of these mediators, some of these arbitrators are actually lawyers that have been practicing. So it's a judicial week whereby you encourage people to come and provide pro bono services. So you say, okay, fine, we can sort out this issue by all pro bono services, give us advice. Parties, do you want to pull out these cases? Yes. Do you want to negotiate and reconcile these issues so that you don't have to waste a lot of time in litigation? Remember, as lawyers, litigation is very expensive. Number one, litigation is timely, because you are depending on other human factors and you are depending on other resources. And it's also expensive because you have to hire a lawyer. So why not have a shorter way of reconciling or solving these matters out of the judiciary and decongest the cases that goes into judiciary? So it's just a service week that aims to enhance reconciliation and solving matters out of court.
And what kind of cases or litigation could be subjected to mediation? Because probably not many Kenyans understand that if I have this kind of case, I can actually opt for mediation instead of going to court.
Indeed, I would say the following. The whole essence of mediation, as provided for under the Constitution, was to bring some sort of mechanism that would speed up the wheels of justice. So that's why in enacting our Constitution in 2010, there was that recognition that one of the past failures of the judiciaries at that time was the delayed delivery of justice, so that cases took too long to resolve within the conventional court setup. And it is for this reason that in 2015, I think towards the end of the term of the former Chief Justice Mutunga, he gazetted the rules on mediation, which were to anchor a pilot project, which effectively was to begin in April 2016, such that all the cases that were to be filed within the Milimani Commercial Court, Family Division, and a number of other divisions that were identified were to first go through the mediation process. Okay. So mediation basically is a situation where you have a dispute or parties to a dispute being assisted by a neutral third party to resolve their conflict. And we need to understand that conflicts and disputes are part of human life. And it also has a historical and also a religious dimension. In the scripture that I subscribe to, the Bible, in the book of Exodus 18, there was a time when Moses used to sit as a judge over the people of Israel. And it came to a point whereby there would be so much for him to resolve. It got so much crowded. He was overloaded in terms of the disputes that were coming, to the point that his father-in-law, called Jethro, told him that what you are doing is not the right thing. Get people who are capable, who can assist you resolve some of these simple disputes, and then what will remain for you
and that's the key.
Are the complex.
That's the key. Those simple disputes. And I'll come back to that. Let's link up with our reporter Patrick Igunza at that event at Safaricom. Patrick, if you can hear me, what exactly is happening where you are?
Thank you very much indeed, Fred. It is a good morning from where we are. We're coming to you from the Michael Joseph Center here, the headquarters of a mobile telephone service provider, Safaricom. And this day, it is quite an important day, especially for the country's disabled individuals, because today the mobile telephonic firm is actually coming up with an M-Pesa application or a feature that will enable those that are visually impaired to be able to conduct M-Pesa services in a manner that will be very, very convenient with them. In not so long a time, as you can see, we will be having this particular function beginning officially, but just before before we actually officially open the function, and wish to invite on set one of the key individuals in today's event, and that's none other than the Director of Resources here at Safaricom, Mr. Paul Kasimu, who will just briefly tell us what we expect today. Mr. Paul. Thank you very much. Good morning.
Good morning, and how are you?
Yeah, very briefly, what is it that we expect today as far as this particular feature for the visually impaired goes?
Today is the International Day of Persons with Disabilities. International Day. Therefore, it's not just the visually impaired, but it's anybody with any form of disability. That could be physical, hearing, it could be limbs. It could also be people with albinism as part of the people that we see as those who are disabled or marginalized. And therefore, we want to celebrate them. What will be exciting today is even to find that our MC is one of those people who is on a wheelchair and doing a perfect job, much better than even people who don't have any form of physical disability. So yeah, celebrating our own and just saying what we've done as a business.
And as far as the M-Pesa feature goes, what is it that we will be expecting that's different from what we've been having in the past?
I think that should be a surprise of the day. I don't want to remove any part of the surprises, but it's also saying that as a company, we continue to listen to our customers and also to work with them in terms of their needs and be ahead of them, and also obviously using digital at core of everything we do. So there's a lot of that coming in. We've seen a few of our products like Masoko coming out and going online shopping at the convenience of your home. But as for the day, we are celebrating our international colleagues who are not, or colleagues who are not able, and making sure that we celebrate them like everybody else.
This, I believe, is aimed towards ensuring that they do continue enjoying your services in a way that will equally be convenient to them, because we can imagine those who are able and those who are somehow disabled are being subjected to the same form of platform. It could be challenging to those that are disabled.
And that's why I was saying I don't want to preempt, but what will come also is about how can a disabled person, visually disabled person, confirm that what has been credited to their account is actually correct. So I think it's one of those things that will say we have overcome some bit of our technology challenges, and we'll also ensure that there is voice recognition that can also make you confirm your balance when you're visually impaired.
Yeah. Thank you very much, Mr. Paul. Much appreciation indeed. There you have it, Freddie. It is a celebration that is aimed at also ensuring that as the world marks the International Day of Persons with Disability, Safaricom will also be taking part in this. And as you've heard from Mr. Paul, a lot of these people that you see behind me will be benefiting from that particular feature that is being included on the Safaricom M-Pesa platform. Much of this will be coming in a subsequent bulletin, but for now I hand it over back to you, Freddie.
Thank you, Patrick. Patrick Igunza there, live from the Michael Joseph Center at Safaricom headquarters here in Nairobi, where the company, mobile telecom company, is celebrating, joining others in celebrating the International Day for people with disability. We're still keeping an eye on events happening outside the DCI headquarters, where NASA leaders, led by CI Senator James Orengo and a host of other lawyers and political leaders, are there. They've been trying to gain access into the DCI headquarters. We cannot see them outside the gate as we speak right now. Those are live pictures there. We're still following the events there. We're made to understand that David Ndii, the NASA strategist, was arrested yesterday in Kwale, could be holed up inside the DCI headquarters being interrogated. For what exactly, we do not know, and I suppose that's why the lawyers led by Senator James Orengo is there and are there. That whole team, we will be establishing in a short while whether or not they've been allowed to gain access into the DCI headquarters. I'm still in studio with Kakai Kissinger, a former, you've worked in the judiciary for quite a while, and the question I'd asked before was what exactly these cases that are subjected to mediation as opposed to court processes are, because Bwana Kamodo Njenga mentioned issues to do with commercial courts, family courts. Are we saying that not all cases can be subjected to mediation?
As we had mentioned earlier, the spirit of mediation is to minimize or to backlog the judiciary in terms of managing cases. And when you realize that, then mediation principles apply across the board in the sense that all civil cases, if we, for example, there are civil cases in nature that have been filed and somebody feels that they should withdraw the civil nature, then they are all at liberty to negotiate and settle.
So they have to be of a civil nature.
Civil nature. Number two, you have family matter related. Issues like divorce, issues of separation, issues of custody of children, all matters that are under family capture. Those are matters that can be mediated. We have environmental cases, disputing over land, over who sold you land, who didn't sell you land, as transaction didn't go well, but now you realize we want to settle it out because, as I said, one of the key reasons is to reduce the time frames. So then that's also an issue that can be solved in a manner before the mediation committee. What might bring a challenge is the issues of criminality, cases of criminal nature. It becomes extremely difficult to have those negotiated. The reason being that there's another arm of government or another investigative body that is dealing with those matters of criminal nature. So that then becomes a little bit a challenge in terms of dealing with the issues of negotiation and arbitration. But all other cases that we've talked about then are subject to negotiation, and nothing stops anybody from negotiating. So went wrong.
If someone steals my cow and I decide, okay, fine, instead of pursuing that particular case in court, let's just talk about it, and probably if he can pay me off, then we'll be good. Don't you think that that one doesn't work that way?
No, you see, when you look at the Constitution, this has actually been answered by the Constitution. Article 252, 189, and Article 113 sets out a mechanism of what we call traditional means and ways of settling disputes. You know, prior to this Constitution and prior to our laws, there were mechanisms in society before that which dealt with negotiating for settlement. And the reason why we came up with statutes and the Constitution is that some of them were criminal in nature. For example, rape will happen in a family and then they compensate a family that has been raped by cows, a number of cows. But that's a criminal nature. So now we have removed that into the Constitution, into the laws, and therefore we still encourage the Constitution, the spirit of the Constitution, the articles I've talked about, still encourages traditional means of settlement disputes, but then they should not be of a criminal nature.
Okay.
So that is the whole aspect in terms of how do we deal with these issues of mediation, reconciliation, alternative dispute resolution mechanisms.
Okay,
traditionally we adopt them.
But there must be risks involved in this kind of mediation, and that's why probably not everyone is as open to pursuing mediation as opposed to going to court. What are some of the challenges that come with mediation?
Well, there are a number, and of course related to what he has talked about. Not every dispute is amenable to alternative dispute resolution, because even the article, which is 159 of the Constitution, which provides for the alternative dispute resolution mechanisms, also goes to add that the nature of the matters or the manner in which the dispute is resolved must not be such as to be repugnant to justice and morality. And the challenge arises when now parties take their matter to court, and then they have to go through the mediation. It is based on the actual cooperation of the parties, because mediation is not something that you can be compelled to. It is actually a mediator assisting the parties to arrive at a solution that is tenable to their dispute. So at the end of the day, the solution arrived at is what is agreeable to both parties, and the culmination of the resolution is where the parties sign a mediation agreement, and that mediation agreement now is what can be enforced by the court. Once the mediation agreement has been signed, then it becomes actionable. You can now in future seek to enforce, say that this is what we agreed with this party, but they have reneged, so you can enforce. You can enforce it.
What about on issues like assault, where someone assaults me? It is my person who has been offended. I am the victim, but I decide, okay, fine, we can discuss this. Is that considered assault because a crime has been committed? Yes, assault is a criminal offense, but he or she decides to pay me off. Can that be considered for mediation?
Yes, it's a related precedent in through the cases that have been decided by the court. One which is popularly known as Mohammed Abdul's case, whereby it involved murder. The accused had murdered somebody, but when now the community came together, they decided to handle the matter through an alternative dispute resolution approach. And though that is not what the Constitution anticipates, the challenge that would arise, because when you have committed a crime, you have actually offended the state. Unlike a civil dispute, which is between parties, a criminal activity is normally regarded as an offense to the state, to the society, to the public, and that's why it's the Director of Public Prosecution who pursues the matter in court. So, if you have been assaulted and you feel that you do not want to pursue the matter further, then the alternative dispute resolution mechanism will take effect naturally, because the Director of Public Prosecution, they will require that the party who was offended, the complainant, will need to tender their evidence. So without the evidence of the complainant, the case will fall flat.
So some of these cases could actually be taken, despite the fact that a crime has been committed. Some of these cases could be considered for mediation.
They could be considered in a certain perspective, which is fairly constrained, because as we are observing, you do not want to have a situation whereby somebody comes and slits your friends or your neighbor's throat, and then tomorrow they come and say, I'm sorry, this, because it will also impair the ability of the society to remain orderly.
But that's a very thin line if you start considering some of these things.
In criminal law, a crime is a crime. Once a crime has been committed, and as my colleague has properly put it, and it's been taken over by the arm of government or the department in government that is meant to deal with the issues of criminality, then mediation efforts are completely shrined. You do remember, for example, one of the most public cases that dealt with criminality and mediation was the Tom Choudhury. If you remember, I think 4 or 5 years ago, Tom Choudhury did whatever he did, and the master in his area wanted to negotiate. But by that time, the Director of Public Prosecution had already arrested Tom Choudhury. So the negotiations were then overtaken by events. The reason being that a criminal offense is a criminal offense, and there are specific instruments and structures of how you deal with the criminal offenses. And so it's one of the difficulties that we find ourselves in. And even when you look at the spirit of the Constitution, it completely avoids that kind of mediation. But then one of the questions that I think we should not lose track of what you asked was the fact that what's the advantages and disadvantages. And some of the things that my colleague talked about, when we are talking about the advantages, is that in mediation is faster. Extremely faster, because you can go there, parties to agree to dispute and agree and come out of it
even the same day.
The same day. It's faster.
Okay.
Because you all agree, because you want to sort the reason why you are going to mediate is you don't want
even divorce.
Even divorce. The reason why you want mediating is you don't want to go into all this prolonged things of calling evidence and all this kind of a thing. Because in law, whether civil or criminal, you must produce evidence to the effect, to support your case. Another thing is that when you are doing mediation, it's more of reconciliatory in nature. Yeah, so you come out of that mediation, both aggrieved parties, but one in a reconciliatory manner. That look, we had a problem, we have solved it, and we've gone. Then the third one is cheap. It's extremely cheap. While the other side of the legal practice is that you'll find that it's very litigious in nature, it's very expensive to hire lawyers to go through the case, it's time consuming, it can take 4 or 5 years depending on the nature of the dispute that is in place. So that's why mediation and the spirit of the Constitution and those articles we spoke about encourages the spirit of mediation. And I remember I talked to you about earlier on, during early days, we used to have mediations. The village elders will sit down under a tree and solve the matter, because that was the nature of, let's solve this matter, there's a problem, but because we still remain a family, we are still united, but we have to deal with it.
But you said there are disadvantages as well.
There are also disadvantages, of course, in terms of dealing with this mediation, is that Suppose after you have done the mediation, you realize that you are duped, or you realize that you did not get really the result or the repercussion, or the justice was not served. So you really feel left out, because as opposed to going into litigation where a different arbiter, a judge in that matter, or a magistrate will deal with it based on evidence and law, here you are submitting yourself to a process whereby you are removing evidence and say, I don't want this thing to go on ahead again, I want to solve this matter amicably. So there are all disadvantages, but at the end of the day, it depends who wants to negotiate, because it's you who brought the claim to court, it's you who brought the suit to court. So when they are going for mediation, you've decided that this is the tail end that I want to reach, and I want to save time.
Okay. Yeah. And someone here on text informs me that there are many certified mediators out there who are not lawyers and are not getting accredited by them. What happens next?
Mediation is a training. You just don't mediate because you want to mediate, number one. Number two, there's a course called arbitration.
They are saying I'm a certified mediator.
Yes. If they are certified mediator, then they should now follow the channels in terms of recognition of them, because there's a channel that deals with it. There's an institute of arbitrators that deals with the putting people on to board, because arbitration and mediation, you have to go through so many trainings and so many courses, and you have to be a qualified arbitrator. And then there are also mechanisms of registering them. These are professional courses. So he knows if they are actually a mediator, they know the mechanism they should follow in order for them to be adopted into the system and to be given work.
Okay. Thank you so much, Kaka Kissinger. You want to add something?
Yes, I wanted to also observe that there is a body which is statutorily established for the accreditation of mediators, called the Mediation Accreditation Committee. It is established under the Civil Procedure Act, and it is through this accreditation body that you are able to be put into the pool of accredited mediators. And when you are in that pool, then you can be considered, if parties are given the liberty to choose who they would want to be their mediator within the court next mediation, then there is possibility that you would be considered for such an undertaking.
I hope your question has been answered there. Thank you so much, Jenga Kamodo and Kaka Kissinger, both advocates of the High Court. Bwana Kissinger is a former registrar of the judiciary. Thank you so much for your very well considered opinions. Time now for a break. When we come back, Brian Okoth will be in studio with views on the news.